each one of us, at least when we meet next time, should be able to greet each other in each other's language rather than our own. I just wanted to pick up 2-3 points that you raised, sir. Though many of us feel that the process is very slow with the judicial process, but I must share that with you, that I can give you the statistics of Delhi alone, because it will take me a long time to take you to the country. Arbitrations, about 49.3% of the judgments in arbitrations come from Delhi court. And my last year's statistics tell me that there is no case, you see exceptions are always there because of certain intricacies that they were, but by and large every case stood disposed of within a period of 10 months from which institution in the court after arbitration. And I want to also share with you that even on the judicial side, an original side suit coming to New Delhi gets disposed of, exceptions apart, within a period of 3 years to 3.5 years. We do call it because there is a difficulty that people who are actually wanted to be on the bench sometimes don't accept it, and sometimes they are not selected. Either both the ways are there. So that is creating our problem. We have vacancies to look at, as our Chief Justice will probably in the valedictory may also tell us about it. If we fill up all our vacancies and we fill up with people with what they are, then I'm sure our judicial system will work far better than what it is. On the question of information on the lighter vein, I must tell you that in this country there's nothing called confidential. Except that if there is confidentiality involved in our contract, supposing I am the person who is recipient of something under the contract of your IPR rights or something else, that also the court will have the examination. The court will have a right, and also the arbitrator will have a right to look at it, whether it can be disclosed or not. And on the lighter vein, I can tell you, I had an RTI, when I was the solicitor of the country, a man moved an application to the RTI to say, please tell me, how many times the Supreme Court judges have gone to a doctor, what medicines are prescribed, how many hospitals has he visited, and what is the expenditure of the government. So there is nothing called confidential now today, so far as we are India are concerned. But yes, I agree there is some issues on a trans-border situation, especially when we are looking at investments coming into our country, and that's where the court looks at it, whether that document is confidential or not, or if it is not, it doesn't jeopardize the other side, it will also allow that to come in. So where the arbitration is concerned, it's all public. Anybody can go and sit there to watch what arbitrators are doing. We have created centers. In fact, if you ever happen to go to Delhi, there's a court next arbitration center, international center, where we are conducting arbitrations. We are now bringing in a concept of bringing specialists or lawyers, like we have Queen's Counsel, my friend Mr. Patrick, or people equivalent to him, to come and preside over the arbitration so that we can expedite our arbitrations also. There's an amendment to the 1996 Act that also India had Arbitration Act in 1996. That's common between Brazil and us, apart from being UK, where we have now made amendments now which have brought time-bound arbitration. And in fact, a concept has been brought about, a fast-track arbitration, if people want that. So situations are changing. I'm sure in times to come, this arbitration shall be in accepted mode. Judicial system process is slow, I appreciate. But the fact is that certain kinds of jurisdictions cannot be put before arbitrations, especially against state. When in India, we didn't get an arbitrator getting a jurisdiction over specific performance of a contract of an immovable property. But what we are finding difficulty in cross-border is this. Take, for example, in a matrimonial dispute. If the couple was married in India, now are citizens of Brazil or citizens of South Africa, they have assets in India, assets in South Africa, they've got a divorce in South Africa. The question is, what happens to their property in India? Because the situs is the question in immovable property. Now, these are questions which I'm sure at least the BRICS nations will be able to sort it out in time to come. That's why I said in the beginning that we need to bring in, at least between our countries, something same all over so that people can take advantage of this head. And maybe if that could be a lesson to others, they will follow us, because we always believe BRICS will be a leader in times to come, nobody else. And everybody will be our follower, whether developed or not developed countries. We now also have a professor of law from China, Fu Yulin. I'm sure she'll be able to give us constructing system of dispute resolution in BRICS. She would help us to what steps that we need to take to strengthen this system. May I invite you, please?
Where is my presentation? I have copied on this. Good afternoon, ladies and gentlemen. I will try to speak in English, and in the end, I will summarize quite briefly in Chinese. Is that okay? Since most of the, yes, I remember I copied on this computer, but in this off. Thank you very much. Yes. Yes, thank you. Okay, thank you. In the past 2 days, I learned a lot from the other speakers, and most of the issues I will cover have been talked about. So in the end, maybe I will focus on some of the issues I think, especially on litigation, arbitration, and mediation. It's my great honor to share my views about the building a system of dispute resolution in BRICS. I will cover to this topic in 3 perspectives. One is the law, and the law including international laws and national laws. And the second will be the practice. The practice including especially arbitration. This will be this arbitration is more international. But I also mention about the justice, because in each of the states, the justice, the judicial review over the arbitration awards will quite greatly influence the arbitration development. And I will also talk about the negotiation and mediation. As you know, mediation in China is a very important way to solve the disputes, especially in outside the court. And also, we do the mediation in arbitration committees and even in the courts. So this is named the Chinese or maybe Eastern experience. But I know as to the professional mediation, maybe other countries go faster than China, but we still have something to share with the audience. And the third aspect will be come to the communication, including the academic communication and education and training. especially training in the BRICS laws. It's a good background that all of the BRICS are the member of the New York Convention, which is a very important convention, covered the arbitration, the judicial recognize of the arbitration awards. So this means we share a very important background, very important rules when we have the dispute and filed in the dispute in the arbitration committees. So this is a very good solution. But still, this convention is only covered the recognition of the arbitration award. We still have many defects. We have other rooms to develop. Just now, my colleague from Shanghai, she mentioned the proofs of foreign laws. And we also have other problems like the evidence investigation and the delivery, and we have many other rooms to be developed in cooperation. I just listed the time of the BRICS entered the convention, New York Convention. And we also have some bilateral treaties between China and Russia, and between China and Brazil. I just omit here. And the third of the international laws is especially on the investment dispute settlement. It's a Washington Convention. But it's a pity only China entered this convention in 1993. Other members of the BRICS haven't been a member of this. But now, since the BRICS have more and more investment in the states, so it's quite urgent for us to set up some way. For example, our leader, President Chen, have mentioned maybe, and other members have also mentioned about the settlement center of investment arbitration. Maybe this will be one of the ways. As to the national laws on dispute resolution, I only mentioned quite little about the Chinese law. We have the first, most important is arbitration. The orientation, the tendency of the arbitration law in China is getting more and more international, and the judicial review in the civil procedure law was revised in 2012. And this new law makes the policy get more and more friendly to the arbitration. And to the international arbitration, we have a special channel and we have a special policy to make it more friendly. Okay, in the end, I will come to the more communication in academic education and trainings. I only mentioned the LLM programs in many universities like Peking University, Tsinghua University, and many famous universities. We have LLM education, especially for the foreign students teaching in English. So we welcome the students from the BRICS to come, and so that's all for my speeches. Maybe my time have been.
No, you can go on.
Okay. Now I just come back to very briefly in Chinese, so that my Chinese colleagues can understand me. 我就是讲到非常简短的讲到从3个层面上讲到这个就是金砖国家的纠纷解决体制，一个是就是国内法和国际法，一个是呢就讲到就是我们的法律实践，这个实践呢可能走得更快，就是特别是在这个除了商事仲裁之外，我们在这个国际投资仲裁这个方面，尽管立法还没有建立，但是呢，在实践中已经开始做很多的探讨。另外一个层面上，我就是讲到了在教育和培训以及学术交流方面，我们进行的一些合作和努力。特别介绍了中国在法律发展，特别是在国内法涉及到仲裁和程序法、司法改革，这个总体的方向是向着越来越国际化，越来越透明，而且呢，对于这个仲裁越来越友好的方向在发展。Thank you very much， 谢谢大家。
My dear professor has put us into a difficulty. I was wondering that if supposing I was to speak in Punjab, I may still get over that I may speak in Punjabi. But supposing I was to go in Tamil Nadu, then am I going to speak in Madrasi? I don't think so. Bengali I can still speak to some extent, having studied something in my school. So I think the last words does convey that we all need to look at own languages and see how do we transmit them. The entire purpose I was mentioning to you, ma'am, that you may consider that since you are one of the authors of the BRICS Law General, if all these 3 summits that we have done, if what all has been spoken, if that could be compiled and distributed amongst the members, that way, before you start the book itself, or finish the book, if what we are saying here, all of us, could be compiled and given in a BRICS Law Journal, that could be a beginning of that. And the suggestion was if all our leaders, most of them are here, may look at it, if we can bring a periodical newsletter of what is the development in each of our countries with respect to each of these jurisdictions, maybe we are able to apprise each other of what all developments are taking place in each of these countries and help us to talk and question better. In India, so far as a mediation is concerned, since you mentioned it in the first stage of yours, wanted to share that in the last about 10 years or so, mediation has taken a very front seat in the Indian judicial system. We can, to give you an example where you are in the capital, we started a mediation center with the professional lawyers here, young people, in 2006 in 2 rooms. And today we have 32 rooms only doing mediation and 60 matters a day. And 60 matters a day is sometimes when people reach there, they think, how is it that you can do 60 matters a day? We have about 242 mediators, trained mediators with us. And to bring this audience to updating it, most of them, at least more than 50% of them, are doing their job pro bono. and have been able to be successful in almost 62.9% cases referred to them. And that's the mediation movement in India. And we have now, the government has taken over it. We find the Supreme Court is taking the initiative from there. We have started a mediation in a very small way in Tamil Nadu, but Delhi again took the lead, and probably we have gone forward to it. We have sent our own mediators to Punjab, Allahabad, Dehradun, other places to train mediators, and I'm sure the situation would be much better when we come to it. The only conflict part that I'm looking at, and I probably need to address to my panelist here, that when we are talking of mediation as part of arbitration, then how do we maintain our confidentiality? Because as a mediator, I may be able to get many things in confidence, which I can't use as a mediator. So the